All right. All right. So we're going to do chapter 10, chapter 11 tonight. And I will tell you when we get to the notes part. Okay, that's coming up pretty quickly. So we're in chapter 10, talking about forensic assessment in juvenile and criminal cases. So when we talk about forensic psychology, remember again the term forensic, although we use that almost exclusively in a criminal justice term, it really is a general term. Forensics has to do with the idea of trying to figure out what happened, as opposed to experimental psychology, which is about predicting, and forensics is about deciding what happened in the past. Okay, so forensics can apply to a lot of things, but obviously it applies to crime scenes and things like that. So forensic psychologists use things from psychology, from psychiatry, and other behavioral sciences to answer questions about people involved in legal proceedings. As we've already determined, that's quite a few people. And obviously, it's probably going to continue to be a bigger and bigger thing. There's several reasons for this. First off, mental health experts obviously have expertise in a lot of areas that are related to litigation. Also, the law permits and even encourages expert testimony, and so we're going to see expert testimony coming from psychologists. And then finally, there's money to be made. If there's money to be made, people will be involved for sure. And so there is money to be made. Hourly rates between $200 to $800 for experts. Obviously, they can make thousands of dollars being involved in a case. Basically, in general, if an expert, whatever an expert is, a qualified expert, can testify if their testimony would be relevant to some issue in dispute. And although obviously expert testimony could be prejudicial, if its value outweighs the risk, then it's going to be included. And so that's something we see a fair amount of. Okay, so basically, whether or not a criminal defendant was insane at the time of a criminal offense is one of the biggest and most challenging questions faced by forensic psychologists and psychiatrists, and for courts to decide as well too. So basically, we need to understand that competence and insanity are not the same thing. So there is an essay choice on the final exam having to do with competence issues and the insanity defense, which is most of the rest of the chapter, okay? So there'll be a essay question asking you to discuss competence issues and the insanity defense. So that's basically page 223 to page 244, which is just about the end of the chapter. Juvenile transfers is the only topic in the rest of the chapter that is not covered. So competence, what do we mean by competence to stand trial? And how do we go about deciding this anyway? And obviously this is not only a psychological issue, it's a primarily a legal issue, so where they are. So the question of whether or not a defendant is competent is both a clinical and a legal issue, obviously. So competence to stand trial refers to the defendant's capacity to basically, within the court system, function in a meaningful and knowing way in the proceedings. Okay, so defendants, so the judge decides, that's called adjudication. The judge may decide they're incompetent if they have some serious deficiency in a number of different areas. Obviously, if they don't understand what is going on, what the legal proceedings are, that's important, okay? If they don't understand the need and how you go about communicating with their attorneys, that's important. And they need to be able to make decisions having to do with their legal situation. So the big principle that all this is tied to is the idea that criminal proceedings should not proceed against a person who doesn't understand what's going on, doesn't understand the nature or the purpose, or therefore cannot aid in defending themselves. It's important part of our legal system, and the law requires defendants to be competent. There's a number of reasons for that. First, obviously, they need to understand the charges that are being placed against them. What are those charges? What does that mean if they're really going to participate meaningfully? Secondly, the idea of punishing somebody is really only morally acceptable if the person understands why they're being punished. And then finally, our justice system is supposed to be fair and impartial, and that requires defendants to be able to defend themselves against a charge. The
Could
national.
you list the question one more
Sure,
time?
sure, Cole, go ahead.
Do what?
Oh, the question again?
Yes, sir.
Discuss competence issues and the insanity defense.
Okay.
So
All right,
big part of, yeah, so that's basically most of the chapter. All right, any other questions while we're
What were the page numbers again?
Oh, page 223 through 244.
Okay, thank you.
You're welcome. All right, so according to Dusky versus United States, a 1960 Supreme Court decision, the national standard for competence to stand trial is, quote, a sufficient present ability to consult with one's attorney with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against the person accused. So that is the accepted legal standard. All right, so that's competence to stand trial. That's one thing. Competence to plead guilty is another related issue. Basically, competence to plead guilty implies that defendants have to understand their alternatives they face, you know, and whether or not they plead guilty or they plead innocent, you know, what are the consequences? They need to understand that. All right, then we have something called adjudicative competence. Nice big word there. So as you can see, competence to stand trial, competence to plead guilty have sometimes been confusing. So some scholars, maybe working on their PhDs, who knows, have suggested the idea of adjudicative competence, which is basically a clear definition of what defendants need in the legal context. And but what you hear mostly is a competence to stand trial. That's the one that's most frequently used. All right, so page 224 talks about raising the issue of competence. And in forensic mental health, this is the most common issue that is raised. Maybe as high as 60,000 motions every year in the United States having to do with competence to stand trial. And again, this issue can be raised anywhere in the criminal process. It can be raised by the prosecutor, it can be raised by the defense attorney, it can be raised by the judge. Once the issue is raised, then the judge orders an evaluation of the defendant to determine if a bona fide doubt exists about their competency. And that would employ, obviously, forensic psychologists or psychiatrists coming in. So after a judge orders a competence examination, then arrangements are made for the defendant to be evaluated by one or more mental health professionals. And obviously both the prosecution and the defense need to agree on that. Now, just because you bring in mental health professionals, that doesn't guarantee the person will be found incompetent to stand trial. The book says the crucial question is whether the person obviously has a disorder would be raised. The question would be raised, does the disorder impair the participant's ability to be involved in the proceedings and to be able to work with their defense attorney? All right, jump over to page 228 if you're following along in your book there. I skipped a number of issues there. In the 1992 case of Medina versus California, the U.S. Supreme Court said that a state can require a criminal defendant to shoulder the responsibility of proving that he or she's incompetent. In other words, it's up to the defense primarily, although, you know, it can be brought up by other people. It's primarily up to the defense to raise the question about being not competent. And most states go back to the civil thing of preponderance of evidence, meaning that the defendant has to show that it was more than likely that they were not competent to stand trial. About 70% of defendants who are referred for evaluation are found competent to stand trial. So meaning only 30% are found not competent to stand trial. And in the cases where it's more than average, but the more rigorous ones, basically the rate of defendants that are found competent is close to 90%, which means it rarely turns out to be an excuse to redeem that. To be found incompetent to stand trial for most defendants, basically the idea is psychoactive medication, and that's considered the best intervention. If somebody has a problem, can we put them on drugs, and can the drugs now bring them to a position where they can understand what's going on? All right, let's jump over to page 232. And that's where we talk about the insanity defense, page 232. Anybody happen to know the very first time the insanity defense was attempted in our country? Either one of you guys know that? A little history question there.
No, sir.
Do you remember President James Garfield being assassinated? Does that ring any bells? That goes all the way back to like 1881, something like that, a long time ago. It was an attempted assassination because there was a Republican Party was split between what we call the stalwarts and the half-breeds. And in fact, Garfield's running mate, Chester Arthur, they were from the two different sections of the Republican Party. At any rate, when Garfield was elected, then one of the guys who had worked the campaign and had not been given a job was upset because he didn't have a job. And so he tried to kill Garfield, the idea being if he killed Garfield, then Arthur would become president, and then that would be a more favorable person. Now, why he thought he could kill the president and then get a job, I have no idea, but maybe he was insane. But anyhow, so he actually tried the insanity defense the first time it was ever tried in our country, and the jury just kind of said, well, yeah, whatever. And he was hanged. Couple interesting points. Number one is he chose to be his own lawyer, which some people would argue is grounds for proof of insanity, right? And also, in addition, he really wasn't the guy that killed the president. It was actually the doctors that killed the president. The president lived about 4, 5, 6 months, and finally died from sepsis. If he'd been today, he'd been in the hospital for a couple of days, been home. But he had a bullet lodged in him, and the doctors, another thing in our country, we thought the British were crazy and believing in germs. We didn't believe in germs in our country. And so the doctors did not believe in doing anything to prevent contamination. So they were taking turns sticking their hands inside the president's wound. And so basically the doctors killed him. Anyway, interesting aside there. So, all right, that brings us to the insanity defense. And we'll talk about it as we go along. The important thing to understand is that insanity is not a psychological concept. Insanity is a legal concept, okay? When we talk about somebody being insane, we're saying they're insane because the legal system has determined they're insane. We use other terms to refer to mental disorders. So basically, any society that respects the rights of individuals, and we do, recognizes the possibility that there are people who don't really know that they're doing something wrong when they're doing something wrong. And so our legal system allows defendants who lack these abilities to try to use what's called the insanity defense. Now, that's another tough one to evaluate. Basically, for one thing, we're primarily talking about the person's mental state at the time they committed the crime. That's really different than competence to stand trial. Competence to plead guilty has to do with your mental state now at the time the legal proceedings are going on. That's much easier to evaluate. To go back and evaluate a person's mental state at the time they committed the crime and maybe nobody else was around, it's very difficult. Obviously, that's a concept of forensics, okay? But you got to do that in some way if the defendant tries to use that insanity as a defense. So juries and judges have to determine not whether the person is currently insane at the time of trial, but whether or not they were insane months or a year or years earlier, whenever the crime took place. And again, insanity is a legal concept. It is not a medical or psychological one. So when we start looking into this, although this is obviously an area where mental health professionals are going to be involved, this is really not the way that we normally operate in the psychological and psychiatric system in terms of clinical help. We're really talking about where the person is now and trying to get them to a better place. And so this is different, okay? And looking for a yes or no answer doesn't fit very well either. So page 233 talks about the rationale for the insanity defense. All right, so again, insanity refers to the mental state of the defendant at the time the offense was committed, okay? Not competence to stand trial. So basically, at the time they committed the crime, how do we look at it, which has to do with their ability to plea bargain. Okay. So what is the legal standard for insanity? The answer is there's not really one exactly, and it varies from state to state. But in all states, the defendant, the presumption is innocence. The presumption is also the person is responsible for the alleged offense if they're found guilty. So therefore, if somebody pleads insanity, again, it's up to the defendant to present the evidence to show they really were not mentally culpable at the time the crime was committed. It falls back on them. So let's look at different insanity defense rules. Stop at the bottom of page 233. The most famous one is called the McNaughton Rule. In 1843, an Englishman named Daniel McNaughton shot and killed the private secretary of the British Prime Minister. And so that was obviously a big high-profile trial. And basically, this ended up being involved in, it went to the House of Lords, and they debated about this. And what they decided is become what's called the McNaughton Rule, which was announced in 1843. And 1843, if you think about your history, that's long before, that was before, we talked about psychiatry and psychology, went pretty far back. So the McNaughton Rule would become the standard for defining insanity in Great Britain, and ultimately it would be the United States. And what the McNaughton Rule does is it excuses criminal conduct if the defendants, as a result of a disease of the mind, again remember in 1843, we didn't talk about Freud, we didn't talk about psychology and psychiatry stuff. The term psychology wasn't around, psychiatry wasn't around. So disease of the mind, number one, did not know what they were doing. The book gives an example, maybe they shot a person, but they thought they were shooting an animal. Number two is they knew what they were doing, but they didn't know that what they were doing was wrong. For example, maybe they believed it was okay to shoot somebody they didn't know. So the McNaughton Rule obviously has been criticized. It's used a lot. Almost half the states in our country use it, but it's been criticized primarily that the cognitive idea of knowing wrongfulness is too limiting and not taking into account motivational and other types of factors as well. So that brings us to a newer thing called the Bronner Rule, which is on page 234. The Bronner Rule is similar, but it says the defendant is not responsible for criminal conduct if he, at the time of such conduct, as a result of mental disease or defect, lacks substantial capacity to either appreciate the criminality, that it's a wrongfulness of his conduct, or to conform his conduct to the requirements of the law, which I think you would agree is similar but different. The book says it differs from the McNaughton Rule primarily in three ways. First off, it uses the term appreciate. By using the term appreciate, we're going beyond cognitive and we're incorporating emotional as well as cognitive aspects. Secondly, it doesn't require the defendant to be totally lacking in appreciation for their conduct, but only a lack of substantial capacity. And finally, it includes both a cognitive element and a volitional element. That means a decision to actually do something, which makes it the defendant's inability to control their action. In other words, maybe they knew what they were doing, but their body was out of their control or something for some reason. Maybe not a different personality taking over or whatever. So, so basically that makes a difference. All right, that's two things. If you remember, in early 1980s, there was an attempt, an assassination of President Reagan. If you remember the actress Jodie Foster, this guy, Robert Hinckley, was kind of chasing after Jodie Foster. What's the term? I don't know, I forgot what the term is. Anyhow, he was trying to get her attention. Obviously, she didn't care about him. But anyway, so for some reason, again, he thought that if he shot the president, then that would get her attention and she would like him, which is, again, really kind of questionable there. So as a result of that attempted assassination, the Congress enacted what was called the Insanity Defense Reform Act in 1984. And basically, what it did was it eliminated the volitional part of the Bronner test, but kept the cognitive part. The idea was to try to make it more difficult for people to use the insanity defense. It didn't do away with the insanity defense, but it changed it significantly. So it basically, so in addition to doing away with the person doing it out of control, it also changed it two ways. One, it prohibited experts from giving ultimate opinions about insanity. In other words, they can make evaluations, but they can't say this person is insane, this person is not insane. Okay, that's left up to the jurors to decide. And it also, again, put the burden of proof on the defendant instead of the prosecution having to prove the defendant's sanity. It was totally up to the defendant. All right, so what are some famous trials? We've already talked about some. Let's talk about some more. Starts at the bottom of page 235. You might remember a number of assassination attempts, okay, or related to. You might remember that John Kennedy was assassinated November 22nd, 1963 in Dallas, Texas, by Lee Harvey Oswald. And then 2 days later, when Oswald was being transported from one place to another, Jack Ruby, who was a bartender, I think some sort of police volunteer or something, anyway, killed Lee Harvey Oswald in front of a national audience. I actually saw it myself. I was watching TV at the time, and it was a Sunday afternoon, and the TV was on, and watching the news, and I actually saw Jack Ruby shoot him, okay? So he tried the insanity defense. Sirhan was the guy who assassinated Robert Kennedy on June 5th, 1968. He tried it as well. John Gacy killed 33 boys in Chicago. Eddie Ray Ralph, you might remember, that's more recent. Eddie Ray Ralph is the guy that shot the Navy SEAL Chris Kyle. And then, of course, Jeffrey Dahmer, that's pretty famous too. So those are all examples of trials in which, famous trials in which people attempted the insanity defense. So has it worked? Well, one of the most famous ones that worked for was the case of Lorena Bobbitt. I don't want to get into too many details there, but you guys can look up Lorena Bobbitt if you don't know who that was, okay? He tried to get even with her boyfriend in a significant way, actually her husband, okay? And basically, she was actually sent in for treatment. But one of the tricks is, obviously the idea of the insanity defense is to get out of the criminal part, but then you still have to deal with the medical part. Sometimes if the defendant succeeds in having the court buy the insanity defense, sometimes they spend more time in a mental institution than they would have spent in prison if they'd been found guilty. John Hinckley, the guy who tried to assassinate President Reagan, probably his proceedings are probably some of the biggest influences on what actually took place. Okay. All right, so let's talk about some facts about the insanity defense. Go ahead and turn over to page 239. By the way, page 238 has a whole article there on John Hinckley. All right, talks about on page 239, public perceptions of the insanity defense. And obviously, most people are pretty upset with that, but they're not happy with the concept. But one of the misleading ideas is it's used a lot less than we think it is. Okay, so what happens to defendants who are found not guilty by reason of insanity? That's what NGRI stands for, not guilty by reason of insanity. Most people think, well, they're not guilty, they go free. Okay, well, that's not true. Okay, basically, there was a study in 1983 that found that defendants in New York who were acquitted on the basis of an insanity plea stayed in the hospital on average about 3 years, in a secure hospital, not a regular hospital. And basically, and the more serious the crime, the more longer they were likely to be detained. So what are some of the current criticisms of the insanity defense? That starts on page 240. Number one criticism is it sends criminals and troublemakers to hospitals and then sets them free. And obviously, we found out that's not necessarily true. And actually, the acquittals are pretty rare anyway. The second criticism is the defense only for the rich, okay? And that people with money are able to do that. And it also relies too much on mental health experts is another criticism. Basically, obviously, anytime mental issues are brought up, both sides are going to bring in somebody, both the prosecution and the defense. In a lot of cases involving case of insanity, basically the experts on both sides tend to pretty much agree, but we don't hear much publicity about that. We just hear about where it doesn't happen. So what are some of the attempts to try to make it better? So from the revisions on page 242. Well, one revision is something called the guilty but mentally ill verdict, GBMI, guilty but mentally ill. In this case, a judge will sentence the defendant exactly as they would if they were guilty of the same offense, okay? And then they start their term while they're in the hospital, and then all the time they're in the hospital, that's counting. If they finish their treatment, then they go into the prison for the time they owe. So basically, they essentially are serving treatment while they're serving their prison sentence. Another issue is the defense of diminished capacity. Some states allow a defense of diminished capacity, which basically says that the person lacked the ability to commit a crime purposely and knowingly, and that can be used. The authors of your textbook believe that the not guilty by reason of insanity defense should be kept as an option. It should be modified maybe and more difficult, but it still should be used. So let's see how this relates to capital sentencing evaluations. On page 243 up to page 244, you can look at that. So that's not in your notes. The only other topic in the chapter talks about juvenile transfer, not part of the test question. During the 80s and 90s, there's a lot of reform in the juvenile and criminal justice systems to basically try to allow more juveniles to be tried as an adult, okay? Basically, by the perception that juvenile crime would increase and things like murder and stuff like that should be taken very seriously. Basically involving the expansion of ways in which a person could be transferred the term. A juvenile transfer means you're transferred from the juvenile system into a criminal court, okay? And again, this varies by state, and basically it's up to the states to make that decision. All right, that's chapter 10. Any questions on that before we go on to chapter 11? You done with note taking? Yes, Alma.
No, I said no, sir. I don't have any questions.
Okay, all right. All right, so again, I will tell you, Colton, do you have anything? All right, let's go to chapter 11. And chapter 11 is not so long. And again, I'll tell you if you need to take your notes. I don't think you do. If I'm wrong, I'll let you know. Chapter 11 is forensic assessment in civil cases. So chapter 10 was on criminal cases. Chapter 11 is on civil cases. Okay. So basically, in civil cases, you can also have experts who testify on basically a number of legal issues. And again, the issue with expert testimony is it can be considered prejudicial. Well, you're saying bad things about my client or whatever. Again, in order to use that, it has to meet two conditions, okay? The expert is permitted to testify if the judge believes that the testimony is based on sufficiently relevant and reliable scientific evidence, okay? So basically, the judge is a gatekeeper. They determine the theory, methodology, analysis that the expert is supposed to use. Judges obviously generally don't do this very well because they're experts in their area, which is not that sort of thing. All right, jump over to page 254 if you're following along. You don't need to take notes, just hop over there. So another area, obviously psychological stuff doesn't get involved in, did somebody beat up the person or tear down their house or destroy their car or whatever, but it has to do with the issue called psychological damages to civil plaintiffs. All right, so sometimes if a person is injured by another party, the injured individual can also claim that, they can get compensation based on the injury. That's the idea of a tort. You've probably heard the term tort reform. A tort is a wrongful act that causes harm to an individual, which is the fundamental idea of civil cases. Criminal and punishment and civil punishment also can be tried for the same act. You might remember the O.J. Simpson case. Remember that in the criminal case, O.J. Simpson was found not guilty, but then he was sued, and the civil trial, he was found responsible for what happened. So again, they have different rules, okay? There are 4 elements that are involved in proving a tort in a court of law, and they all involve behavioral issues to some extent. All right, the first is torts occur in situations in which one individual owes a duty or an obligation to another. For example, you're a teacher and you're responsible for the children in your classroom. Or you're a bus driver and you're responsible for your passengers on your bus. Or you're in the medical profession, okay? So basically, that's where the person being sued has some sort of legal obligation, and that's it can be important. Secondly, a tort requires generally that one party either breached or violated a duty that was owed. The breach duty can be due to negligence or intentional wrongdoing. So negligence has to do with the idea I wasn't trying to do something wrong, but I wasn't doing my job as well as I should. If you haven't already experienced this, you probably will at some point in time, either yourself or sometimes a parent, where you have to sign some piece of paper to let a kid go off to camp or something that says, hey, I'm not going to hold people responsible for what goes wrong. Well, you can sign the paper. It really doesn't make any difference, okay? The idea is to try to keep people from suing when they shouldn't. The reality is if you sign the piece of paper that says you're not going to sue, but then somebody did something wrong, it doesn't matter. You can still sue them, okay? This idea is just trying to convince people not to sue. So negligence is a behavior that falls below the standard for protecting others from unreasonable risk, okay? Intentional behavior is when the person meant for something to happen, like one of the cases that I was on the jury panel for but not chosen was where a guy was renting space from Channel 34's transmission tower to transmit his radio station channel, and he didn't pay stuff for a long time, and one of the employees at Channel 34 went in there and destroyed all the guy's equipment. Okay, that was intentional. Okay, there was no question it was intentional. We all understood that. The issue was going to be how much other damages were going to be. All right, third is the violation of the duty also must have been the proximate cause of the harm. Okay, a proximate cause is one where it's obvious and substantial reason why the harm occurred. Obviously, getting a sledgehammer and destroying somebody's equipment, that's pretty much proximate cause. Okay. Fourth, a harm or loss must actually occur, and the harm has to involve some type of legally protected right or interest for which the person can seek to recover damages. Okay. Damages can be obviously destruction of personal property, physical injuries, and or emotional distress. That's the infamous pain and suffering. In the case of the guy who did that, I think most of us were comfortable with the idea that the guy needed to really pay for all the damages to the person's radio equipment. The issue that was involved was there were going to be two issues raised. One is he was claiming to have lost all sorts of business that needed to be compensated for, and the radio station was down. The question bouncing in my mind was, if you didn't make enough money to pay your bills, and how successful really was your business? But the other thing was they also wanted punitive damages. Punitive damages we'll talk about in a minute. Basically, that's just where you're just making the person pay more just to punish them. Okay? It's like a fine. And that was the question. They wanted a couple $100,000 in punitive damages. I think I would have been okay if I'd stayed on the jury to make him pay for his damages. He had his fund, he's got to pay for it, but not for the other part. In recent years, the courts have basically moved in the direction of that psychological symptoms of mental distress are more likely to be compensated even if there's not physical injury. So that became an issue. Plaintiffs can seek compensatory damages. That's where you're being paid like your medical bills and the physical bills and all that. And then punitive damages, that's just punishing the people for what they did or did not do. Okay, that makes a difference. All right, that brings us to workers' compensation on page 257. So basically, workers' compensation has to do when a worker is injured on the job, and of course, their job. Okay, and basically, we obviously have lots of stuff set up within the system already to do that, to try to get a person quickly through the system to try to not have a tort. Okay, that's known as workers' compensation law. That's the big part of our system. Okay, workers can generally seek compensation for physical and psychological injuries suffered at work, the cost of whatever treatment is then given, lost wages because they couldn't work, and the loss of future earning capacity, which is another tricky one to figure out. How much money do we really think somebody would have made in the future? Determining that is obviously very, very difficult. And of course, psychological injuries or mental disorders arising from employment can be compensated, but that's also difficult to evaluate. And that's where clinical psychologists are often brought in to make that evaluation and to determine what might have happened there. All right, let's bounce over to page 260 and look at civil competencies, which is a little bit different issue, obviously. Okay. All right, so the question of mental competence is also raised in several areas of non-criminal activity, and those are called a term of civil competencies. Basically, it has to do with, again, whether or not the individual has the capacity to understand the information involved in their decision-making, and can they make an informed choice about what to do? In other words, in trying to figure out who owes money and who doesn't. All right, another issue, also on page 262, is competence to execute a will. That's called testamentary capacity. And that pops up sometimes when somebody dies and they left a bunch of money. Maybe they had $1 billion and they had 5 kids and 20 grandkids, but they left all the money to their pet cat. You know somebody's going to challenge that, okay? And so sometimes people challenge a will because they say the person did not have the mental capacity to do that. So the legal standard goes back to Banks versus Goodfellow in 1870. So that's an old case that hasn't changed. So the legal standard has 4 aspects. Number 1, the testator, that's the person writing the will, must know at the time of making their will that that's what they were doing, okay? They need to understand, yes, I'm making a will, I'm making this decision about what's going to happen. Number 2 is they have to know the nature and extent of their property. You know, if they have $1 billion but thought they only had $10, obviously they might have done things differently. 3 is they must know the natural objects of their bounty, okay? Who's it going to go to or not go to? And 4, they must know the manner in which the wills are making and distribute their property. You got to understand that, okay, what happens. All right, next topic is called psychological autopsies on page 263. Sometimes clinicians are called in to basically determine, and this is really forensics again, to determine what the person's state of mind was before they died without having been there, okay? Obviously, in those cases, you can't talk to the person, and so those are what are called psychological autopsies. There's no standard format for psychological autopsies, but obviously you have to rely on information from third parties who knew the person, and also like medical records, things like that, or other types of records. All right, another related issue on page 265 is child custody and parental fitness. That's a big one our day too, okay? Currently, the standard for custody decisions is what is the future best interest of the child. Obviously, historically, that wasn't always true. For a long time, as kids went to their mother's, period, but that has changed, okay? Mental health professionals are called in to basically, and it's a pretty tough one to decide that sort of thing because you're really making very, very important decisions. All right, jump to page 269, bottom right-hand corner, civil commitment and risk assessments, okay? All 50 states plus the District of Columbia have some sort of laws related to civil commitment. It has to do with custody and restraint of persons who, because of their mental conditions, are a danger to themselves or to others, and who are basically mentally disabled so they cannot take care of themselves. That's a big, tough issue. My sister, who, if she'd been here, I've used her before in this class at one point in time. She sat on the bench doing this sort of thing, the commitment issues, and so that's a big deal. There are 4 types of commitment procedures. The law allows 4 of these. The first one is emergency detention. Second one is voluntary inpatient commitment. So emergency retention, voluntary inpatient commitment, involuntary inpatient commitment, and outpatient commitment. And those can be decided. So obviously, what makes a person a danger? Well, that's difficult to decide, but anyhow, okay. So that's it. That's all I have. So that's just one test question out of all this. So remember that you have an extra. I think you guys have both turned in your papers. Not everybody else, okay. Remember, there is a Article 7, okay. So basically, we'll do chapter 12 and 13 next week, and we'll do chapter 14 and 15 the week after that. Anybody got any? Yes.
No, okay.
All right, any questions?
No, sir.
All right, and y'all get out in what, 45 minutes?
That's right.
Okay,
Thank you.
all right, see you guys next week.
Bye-bye.
All right, bye.